number 83, the people of the state of New York versus William Harris. Good afternoon, counsel.
Good afternoon. May it please the court, my name is Daniel Schumeister, and I represent William Harris, the defendant appellant in this case. With your Honor's permission, I'd like to request 2 minutes for rebuttal.
You may, sir.
Thank you. The trial court in this case committed presumptively prejudicial error requiring reversal when, on the last day of trial, and contrary to its explicit statement on the second to last day of trial, it completely denied Mr. Harris his Sixth Amendment right to a summation.
Before we get to that, counsel, let's talk about preservation.
Sure, Your Honor.
Was this preserved?
Your Honor, I do not think preservation was required in this instance because preservation was not realistic given the way in which proceedings unfolded. I would say, Your Honor, that there was a lot of speed and surprise with which everything unfolded. As I mentioned, on the penultimate day of trial, the trial court had said that that the parties would sum up as well. And then, surprisingly, and I would say out of nowhere, the court said that it found it had the discretion not to hear.
So would this be a different case if the day before the court had said, by the way, we're going to finish up tomorrow and I'm not going to allow closing arguments, summations?
It might be a different case, Your Honor. I would say, though, that overall the court needs to take into account the totality of the circumstances there. I grant, I'm sorry, go ahead, Your Honor.
I'm sorry, let me clarify. A different case as regards to the requirement of preservation, not necessarily the merits.
Whether preservation would be required if it was, if there was
So
a
if you knew
warning.
if there was a warning the day
Sure.
before, would preservation then be, would you have been required to preserve this?
I think it might be a different case, Your Honor, yes. Of course, that is not what happened here, and I would note that
No, the interesting thing is here is you have a constitutional right to a fair trial, right? And you've argued that. You're arguing that here, right?
Sure, Your Honor.
Okay. So the kind of the odd thing in this case is that the court did not make a legal error. The CPL, in the strange anomaly that we have, does allow the court to deny summations. So the question for us really is if you don't have to preserve that constitutional error because the court didn't make an error, then can we get to the merits? You see what I'm saying?
I believe I do, Your Honor. I would say that you're referring, I believe, to CPL 35010.
I'm trying to throw you a rope here to argue preservation. Giving you a big, long rope here for you to go ahead, at least argue, then we can talk about the merits anyway. All right.
Well, I do not think that it needs to be preserved under these sorts of circumstances where enforcing a preservation requirement would, in effect, cause the waiver of the Sixth Amendment right to a summation, which is within the Sixth Amendment right to counsel.
Well, all right. Anyway.
Absolutely.
Back to the merits.
Sure. I do want to emphasize, however, that everything unfolded quite quickly. As you might see in the record, the defendant was not yet standing up when the verdict was being rendered. And I do think that counsel made clear her displeasure with what had unfolded when she said, if you could have heard me further to elaborate. However, it really was a quite quick.
Well, is that close enough in time to preserve if we think preservation is necessary? That comment by counsel?
No, Your Honor, I don't think so in these circumstances because the record was closed, because the verdict had been entered. And I think it's clear from this court's decision in Carter and then a more on-point decision from the First Department in Angola that once the verdict has been rendered, the record is closed, and you cannot reopen it to reconsider the issues. I would also point this court to the court's decision in McAlpin, where when there was no ample opportunity, then when there were only moments before the imposition of sentence in that case, preservation was not required. And similarly in Conseco, where there was no actual or practical ability to object, the court heard and decided the merits of those cases.
Counsel, I have a slightly different question. The respondents in their brief actually make an on-the-merits argument, which you don't seem to address in your reply. Your reply seems to indicate all they made was this preservation argument, but on page 22 of their brief, they say, in any event, even if defendant had preserved his claim that CPL 350 is unconstitutional, that claim would fail on the merits. And they argue that, given that this is based on a right to counsel theory and Herrera, that wouldn't apply where there is no actual deprivation of liberty in a misdemeanor case, for example. So what's the response to that?
Well, Your Honor, I'm not sure I follow your question. I would say that, to begin with, even an error like this is structural error in the federal jurisprudence, and there is no harmless error.
Their argument is, okay, even if you would preserve this, you're grounding your argument in Herrera, which is a right to counsel type of case, right? And that doesn't apply, the argument goes, in a misdemeanor case like this, where there's no deprivation of liberty.
Well, Your Honor, there was a
There's no right to counsel.
There was a deprivation of liberty in this case because Mr. Harris was sentenced and served 3 months.
He's a
Yeah,
B
that's-
misdemeanor, but I think the judges were, the statute refers to both misdemeanors and violations. Sure. So in that instance, the people may be correct that you're not entitled to a right to counsel in violation, let's say harassment 3, something like that. And in that situation, you wouldn't be. So that part of the court wouldn't be required to deal with that constitutional issue, but you would be on a B misdemeanor.
Right. It's an
Isn't-
as-applied, not a facial challenge to statute.
I would say it is as applied. I would also say that this court held in Garcia in 1999, it's the threat of imprisonment that makes the right to counsel attach in cases in this state, and in any event.
Is there a statutory right to counsel for misdemeanors in New York?
I cannot answer that off the tip of my tongue, Your Honor, whether there's a statutory right for misdemeanors, but I would say that I believe in Garcia the court found that that right to counsel attaches when there's the threat of imprisonment under the Constitution, but I don't want to represent that I recall whether there's a statutory right for that as well. I would say that there is no indication from there's no indication from the record that trial counsel would have, as a matter of strategy or otherwise intentionally, decided to waive the right to a summation. For instance, the arguments that would have been made were not going to repeat the arguments that were made during the motion for trial order of dismissal. During the trial order of dismissal motion that the trial counsel made, she made it with a prima facie framework that, of course, is not what would be at issue in a summation where the court would be weighing for reasonable doubt. And there were serious arguments to be made, for instance, in terms of whether the single crack pipe that was eventually tested was, in fact, Mr. Harris's or perhaps the complaining witness's instead. That's partially made clear because there were certain issues as to the chain of custody and the consciousness of innocence that was mentioned during sentencing by trial counsel. We do, in addition, ask that not only should the conviction be reversed, but that the accusatory instrument should be dismissed given the fact that Mr. Harris has served a sentence, that it's a relatively minor offense, and that no other.
Do we have jurisdiction to do that?
Yes, Your Honor. Under People v. Allen and People v. Burwell, the court has previously done just that, pointing to cases that were, in fact, for, I believe, more severe offenses than the one that Mr. Harris was here convicted of.
Thank you, counsel. Counsel?
May it please the court, Rebecca Viscatus for the respondent. Defendant did not preserve for appellate review his claim that he was denied the opportunity to present a summation.
Do you agree that the correct standard for determining whether preservation was required is whether defense counsel had a meaningful opportunity to object?
For preservation, no. That meaningful opportunity language that defendant relies on comes from a federal Fifth Circuit decision about the implicit waiver of the opportunity
What
to.
about Consecao?
I believe that this case is more in line with this court's jurisprudence about the ability to object in other right to counsel contexts. And in those cases, the Umali and Narayan and Garay decisions, this court has held that preservation is required where counsel is present and available to register a protest. So in our view, all that was required for preservation to be required here was that counsel had some notice of what was happening.
So I'm the judge. You get up, and I say, no summations, guilty.
I think that when you say no summations, yes, that is the
I just said no
opportunity-
summations and then guilty. You're in the room.
Yes.
You think that there's an opportunity there that fits within the prior case law for you to actually object?
I mean, that's certainly a tighter,
No, it's a yes or no on this.
yes, I think
When would you have made that objection?
immediately when the court says no summations. And perhaps you don't get the word out, but perhaps you start to raise your hand, perhaps you start to stand up and get that judge's,
No summation, guilty.
I think the no summation gives an
You
opportunity.
didn't actually interrupt me there, so you think you could have?
Well, I have no objection here.
Well, maybe you should. You don't know how I view that.
I believe that if the court is saying what it's about to do, then that is defense counsel's cue to give an objection. And here,
So then is
Did
your
she
argument-
register a protest?
No.
The defense counsel by saying, well, I would have said to you, Judge, that he had no knowledge that there was cocaine in that crack pipe. She didn't say that?
she,
Right after he stopped talking?
she did indicate that she had some elaboration on what she had said in her motion in support of a trial order, of her motion for a trial order of dismissal. But when she said that she could have further elaborated, she was not registering a protest. She didn't say, I could have further elaborated, and in fact, you denied my right to do so. She was stating a fact.
If she
that-
did so after my example, no summations, guilty. If you had then, you're the counsel, said, oh, I object, I want a summation, is that preserved?
I think that that's a tricky question because
It's a yes or
whether-
no. It's a yes or no.
I would say yes, that would be registering a protest, and I think...
Even though it's after having said no summation, after having said the
So I
verdict.
think what complicates the issue is that you have to look at whether the court could change its mind at that point, and I
And
think...
can the court, have we said that? Is there some statute that permits that?
This court's jurisprudence has said that in other cases, there was not an ability for the court to change its mind. I think that there could be a factual analysis of that, and I don't think that that was enough of an issue in this brief for us to have fully
Well,
addressed
given
whether
what
it
the
can be a
rules of,
factual-
given the goals of the rules of preservation, what should be the correct rule? In my example,
if counsel registers a protest after the fact,
I'm
or
asking you, in my example, given the goals of the rules of preservation, how should the rule be deployed to resolve that hypothetical?
in your hypothetical of counsel not objecting immediately?
No
or-
summation, guilty.
I believe that counsel had an opportunity to object when court said no summation, and the court could have corrected the alleged error at that
They
point.
speak at exactly the same time as the judge. No summation, guilty.
Yes.
Okay, can I ask, do you agree that generally a Sixth Amendment right to counsel constitutional claim does not have to be preserved? Generally, that's true, right?
Correct, yes.
All right. So in this instance, there was no statutory violation by the court. The court was actually following the statute as it's facially written, and there was a subsequent right to counsel argument that was brought before Appellate Division, and now we've got the same issue basically before us. So isn't really under the kind of strange circumstances of this case, because of this statute, it seems that preservation may not really be required here. So what do you have to say about the merits?
About the constitutional challenge to the statute, or?
Yeah, the validity of the statute.
Sure. So So the validity of the statute, first of all, there was no argument at the trial level about defendant's constitutional
No,
rights.
I understand all that. I
being
understand that, but
violated.
we both just agreed, you don't have to preserve that. Okay.
Right.
So,
So here, because under both the federal and the state constitution, you are not necessarily entitled to counsel if you are not ultimately sentenced to
yeah,
imprisonment.
but this is a B misdemeanor, right? So he can go to jail up to 90 days on a B misdemeanor. So I get what you're saying about violations, but that's not relevant here. I mean, the way you read on the statute on its face, somebody can do time. So they got a right to an attorney.
So that's where the waiver comes in here, because in addition to just preservation, it's clear that defense counsel can waive the opportunity to give a summation. And that's
But
true under,
You're not arguing that that's what happened here, are you?
yes.
Are you?
That,
Okay,
that there was.
what do we look for in the record to evince the waiver?
Sure. So I think that you look for the fact that there was an opportunity to object, and especially here where you have the court explaining multiple times that it's not going to hear summation and that it's going to render a verdict without summations, and then beginning to render that verdict and initially announcing an acquittal on some of the charges and then telling defendant to stand up to receive the rest of the verdict. You have this extended opportunity here through all of that in which
You have to
counsel
waive
is
before
silent.
or after?
Sorry?
You can have the waiver post,
The waiver would need
as
to,
opposed to pre.
the waiver is contemporaneous. The waiver is when the court is saying that it is going to render a verdict without hearing summations and counsel is silent, that can demonstrate a waiver. And here-
Counsel, let me ask you this question. So would you agree that the defendant's right to counsel attaches upon the deprivation of his liberty?
Yes.
Would you then also agree that there's a violation of that right to counsel when the judge prevents his defense attorney from presenting a summation to the court?
If the defense attorney has not waived the opportunity to give that summation. And here, in addition to just the opportunity, we have circumstances that actually demonstrate that this may have been a strategic choice. Counsel had
Not to
just...
sum up?
Yes, which this court has recognized can be a valid strategic choice
Sure.
in the Aiken decision.
Okay.
And here we have defense counsel who had just made the argument in support of her motion for a trial order of dismissal.
Yeah, but a trial order
She had-
dismissal just goes to the elements. It does not go to so-and-so is not believable, so-and-so, was impeached. I mean,
Sure,
they're
but-
not the same.
There really wasn't, there was no indication that there was going to be a credibility argument about the
We
drug
don't know,
possession.
do we? Because the judge didn't allow the summation.
I believe that based on the totality of the circumstances, if you look at the questions that counsel asked on cross-examination of the witnesses, and if you look at the one sentence extra she then added in summation, or in her sentencing argument.
I know this is a court of law, all right, and we don't make our decisions based on equity. But is what happened here fair?
Yes, because under these circumstances, there is an indication that counsel waived the right to give a summation. Counsel may have...
Counsel stood up and said, Judge, I don't need to sum up, we're ready to proceed to verdict.
No, but that's not required. The entire line of federal cases that both defendant and I have cited in our briefs establish that there is an implicit waiver available of the opportunity to give a summation. And in many of those cases, we have circumstances very similar to here, in which counsel's silence when the court explicitly said that it was about to render a verdict without hearing summation was enough to show an implicit waiver of that opportunity.
Thank you,
This is something
counsel.
that can be waived.
Thank you. Counsel?
Thank you, Your Honor. Just to step back to the beginning of the people's presentation, when there's a discussion of this court's decisions in right to counsel cases and then the federal cases, I think that the single common sense principle in terms of the question of whether there was an implicit waiver comes down to whether there was a chance to object and counsel did not take the chance to object. I think realistically, under the circumstances of this case, there was no chance to object. Now, the people have discussed a lot of the federal cases claiming that they are quite similar to these circumstances. I would say that overall, none of them bear much similarity to this case at all, either because there was a recess or there was a large run-up to the denial of a summation, or counsel clearly showed that she was able to interrupt at that time, for instance. And so from all of those cases, I don't think they...
So you're saying those cases are about an opportunity to consider and act and/or act?
Yes, there was both an opportunity to consider in those cases, which I think is something that the Fifth Circuit cases really emphasized, and also for sure an opportunity to act, which I do not think we had here. Now, just to clarify, it's our position that under Garcia, the right to counsel attaches once there's just a threat, not...
Well, and the thing is I suppose you can make an argument, which seems to be made on these federal cases, that implicit waiver may be a possibility, though it's not been imported into New York law. But I have a problem with the idea that a summation may be implicitly waived, but that is not the same as the right to counsel being implicitly waived. Those are separate things, and none of that took place here, and there's no record to support that.
I agree, Your Honor, absolutely. I would also say that the people mentioned the Aiken case. There, I think this court in its decision made clear that counsel in that case, when that was a traffic violation case, had nothing else to add. As I hope I made clear in our briefs and when I was standing up earlier, there really was something to add here, a real question of reasonable doubt as to whose quote-unquote crack pipe that was, whether it was the defendant's or the complaining witnesses. And just at base, this really was not fair to Mr. Harris. The right to summation is quite an important part of the adversary fact-finding process. The Supreme Court made that quite clear in Herring, and this court should reverse the conviction and dismiss the accusatory instrument. Thank you.
Thank you, counsel.